Everyone, and welcome back to another video. In this video we're going to talk about Lucy Connolly, a childminder and the wife of Conservative Counsellor Raymond Connelly, who has been jailed for 31 months. Now this has led to a number of commentators on the social media platform X bemoaning the fact that she's been sent to prison simply for posting an inappropriate tweet and that she is now a political prisoner. So in this video I'm going to go through the facts of this case and I'm going to outline the judge's sentencing remarks so you can decide for yourself whether she is indeed now a political prisoner and is the victim of two-tier policing. Welcome to my channel, Andy on Crime, where I talk about high-profile criminal cases and other aspects of criminal law in England and Wales. And before we get into the video, if you do want to support my channel, then please click the link in the description and sign up with NordVPN for a big discount. I would massively appreciate that. With all that being said, let's get into the video. So I'm just going to dive straight into the facts of this case, and the background behind this offence is the tragic murder of 3 children in Southport following a mass stabbing on the 29th of July 2024. Now this tragic incident led to false information appearing online about the identity of the murder suspect, stating that he was an asylum seeker who had arrived on a small boat and that he was a Muslim. Now later that same day, Lucy Connolly tweeted the following message, which I put on screen. Mass deportation now. Set fire to all the fucking hotels full of the bastards for all I care. While you're at it, take the treacherous government and politicians with them. I feel physically sick knowing what these families will now have to endure. If that makes me racist, so be it. Now, following the incident on the 29th of July 2024 and that tweet, over the next 6 days, a series of riots and acts of mass disorder took place, fueled by anti-immigration sentiments, Islamophobia and racism. And over 1,000 people were arrested, with over half of them going on to be charged. Some of them received lengthy prison sentences, having pleaded guilty to offences such as violent disorder and assault on an emergency worker. Now in early August, Lucy Connolly was arrested and remanded into custody. She appeared at Northampton Crown Court on the 2nd of September 2024 via video link from HMP Peterborough, and she pleaded guilty to the offence of publishing material intending to stir up racial hatred, contrary to Section 19 of the Public Order Act 1986. The maximum sentence for this type of offence is 7 years in prison. And on the 17th of October 2024, Connolly was sentenced to 31 months in prison. In this part of the video, I'm going to go through the judge's sentencing remarks to outline how he came to the sentence that he did. And I've put a link in the description if you want to read them in full, and I would encourage you to do so. Now, the judge outlines at paragraphs 1 to 9 the factual background to this case, which I've mostly covered in the earlier part of this video. And the judge highlighted at paragraph 7 that the tweet of Lucy Connolly that I read out earlier was viewed 310,000 times, with 940 reposts, 58 quotes and 113 bookmarks. Now, when it comes to sentencing, judges don't just pull sentencing out of thin air. The Sentencing Council sets a number of guidelines which judges are required to follow. And if you want to read any of the sentencing guidelines for pretty much every offence that we have in England and Wales, then you can simply Google it and it will take you to the relevant part of the Sentencing Council website. Now, when it comes to sentencing itself, what judges are required to do is to place the offence within a category, which is generally determined by 2 things. The first thing is culpability, how culpable the individual is for their actions in relation to that specific offence. And the second thing is the harm caused. The more severe the harm, the higher the category. And the judge considers a number of factors and then places the offence within a category. So for example, if there's 3 categories of culpability and 3 categories for harm, an offence might be a 2B, so medium culpability and medium harm. That then translates to a grid, which identifies a starting point, i.e. the point that the judge must start on before considering whether to lower or increase the sentence, depending on other factors. Now, when it came to the categorisation of this offence, the judge determined that Connolly's culpability was in the highest category, i.e. category A, and this was accepted by Connolly that she had intended to incite serious violence. When it came to harm, it was also agreed that this was in the most serious category, category 1. So that being the case, the starting point, and I've put the sentencing guidelines on the screen now, the starting point was one of 3 years. And the range for a Category 1A offence was 2 to 6 years. So any offence below or above that would need serious justification as to why the judge came to that conclusion. So having identified the starting point, the judge will then adjust the sentence up or down depending on any aggravating or mitigating factors. And in this case, the judge found that there were 2 significant aggravating factors. Firstly, at paragraph 13, the judge stated that the harm that was sought achieved widespread dissemination through social media, and I've already given you the number of times people viewed it and interacted with that post. And the second significant aggravating factor, which is at paragraph 15, was that the timing of the publication, i.e. the timing of the tweet, was during a particularly sensitive time following the murders of 3 children. So the judge concluded, based on those aggravating factors, that the sentence would require a significant increase. In terms of mitigating factors, and these are factors that might lower the sentence, the judge highlighted the following. Connolly had no previous convictions for any criminal offences. She had a good family and she was the mother to a young daughter. And she had previously lost a very young child some years ago, which caused her mental health to deteriorate, although at the time of the sentencing there was no recent psychiatric evidence to support her current prognosis. The judge also, at paragraph 22, highlighted that whilst Connolly regretted her actions, he had seen from her own words in the days following the tweet that she had little insight or acceptance of her actions. So weighing up the mitigating and aggravating factors, the judge determined that this required an uplift from the starting point of 3 years, and he increased it to 3.5 years. The judge then reduced the sentence by 1/3 to take into account her guilty plea at the earliest opportunity, and that resulted in the sentence being reduced from 3.5 years to 31 months, which is just over 2.5 years. Now, as a quick side note, as the sentence was over 2 years, it was not a sentence that was capable of being suspended. Only sentences that are greater than 14 days but less than 2 years can be suspended. So if you're wondering why the judge didn't consider suspending the sentence, given that the sentence was 31 months, this was not a sentence that was open to him at the time. So returning to the question that I posed at the start of this video, is Lucy Connolly a political prisoner, as some online commentators are suggesting? Well, in my view, that's simply a ridiculous thing to suggest. She committed an offence which has been a criminal offence for a number of years. She pleaded guilty to the offence. She was perfectly entitled to deny the offence and contest a trial. In pleading guilty, she accepted that her tweet was intending to stir up racial hatred. She had access to legal representation, which she had in all of her court hearings. She accepted the categorisation of the offence in the guidelines, which have been in existence since October 2019. That categorisation puts the offence in the highest category, attracting a starting point of 3 years in prison. The sentence was one that was well within the guidelines for this type of offence, and ultimately, if she disagrees with the sentence, she can appeal against her sentence. In summary, this was an appropriate sentence for someone who pleaded guilty to this type of offence. Now, I've seen a lot of critique of the sentence And the way that people are tending to do this is to make false equivalences with other offences, such as the sentences for people convicted of possessing indecent images of children. Now, in that example, you are comparing two different sets of sentencing guidelines with different maximum sentences. If your argument is that sentences for possessing indecent images of children should be increased, then that is a perfectly legitimate and sensible position to hold. But sentences for these offences should not be the comparison for all other offences, which is something that I often see on social media. But what do you think about this sentence? Was it fair? Was it too harsh? Was it not harsh enough? Please let me know in the comments down below. That's all for this video. I hope you found it informative, if nothing else. If you did enjoy this video, then please do give it a like. And if you'd like to see more from me, then please do subscribe to my channel. Thanks for watching. Take care.